Good afternoon, everyone, and thank you for joining us for today's Workers' Compensation 202 webinar. I'm Jen Donovan from the board's Stakeholder Engagement Unit, and joining me today is Joe Cavalcante, the board's advocate for injured workers. Today, Joe will take a deeper dive into best practices workers can use to access their workers' compensation benefits, including understanding labor market attachment, details on benefit periods and how benefit rates are calculated, the importance of items such as the degree of disability and the carrier continued payments order, how advocates can help workers and comply with privacy provisions, and the Workers' Compensation Board's New York Medical Treatment Guidelines. We will be taking all your questions via chat today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joe will answer as many of your questions as he can, but if there are any he doesn't get to, or if you think of something after our session ends, we will be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you would like to discuss more in depth with the board, please share that topic along with your contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are configured so that only panelists can see any questions or comments that come in, so you do not have to worry about others seeing your contact information. And with that, I will now hand it over to Joe, and we will go ahead and get started with our presentation.
Well, thank you, Jen. And hello, everyone. Welcome to the last Advocate for Injured Workers webinar of the autumn. I know, it is still autumn. Here's our agenda for today. We are doing a longer webinar than usual because we have so much substance for you. We're going to begin with some important foundational information, all those little details you never knew, but you're going to count on and use. Then we will spend much of our time talking about indemnity payments. Then a section on medical care and opinions. Best practices for payers is next. And then we'll conclude with appeals and give you some resources and the settlement too. Okay, the Advocate for Injured Workers, that's your first topic. That's me, actually. I'm the manager of an Office of People, and technically my title is Ombudsman. That means I'm someone who is devoted to the health of the system. How well is the system working? Is it working as designed? Okay, so that's what I do. And I help the workers. So I come at this from the workers' perspective. And my unit helps workers with the more difficult and complex claims. And boy, do we. We also handle the fatality claims. There is a fatality benefit in the system, thankfully. And I work a good deal with the 9/11 community. This is a situation that is ongoing, and Governor Hochul has for several years now been highlighting the 9/11 assistance programs. So we would just like to show you these two in particular. On the left there, you see the World Trade Center Health Program. Well, if this was your screen, you could click more to learn more. So maybe you want to come to this page yourself and check this. The World Trade Center Health Programs are federally paid health care, which consists of both treatment and medical monitoring for people who are impacted by the events of September 11 and the aftermath. So we encourage anyone who fits those criteria to get in touch with the World Trade Center Health Programs and enroll. They're national, by the way. So if you're living outside the New York City metro area, it's okay. There are providers probably near you who can help you with this. And then on the right, you see the September 11 Victim Compensation Fund. There is financial compensation available to people, again, who were impacted by the events of that day or in the aftermath. That includes the survivors as well as the surviving families of people who were lost. So you would apply directly with the Federal Department of Justice. That's who actually administers this. And so we encourage you to check that out as well. And of course, I do report directly to the commissioner of the agency, which makes it easier for me to bring issues forward. So here's another one. This is coming out of Jen's unit, the publication. We have so many publications. Look at this list. This is just the list right here for work. You keep going down that page, we have publications devoted to employers and healthcare providers and on and on. So the point here, would you like some education? Would you like some facts you can depend upon? Go to our website, go to the bottom of the first page and click publications. You will see this, and then you will have all kinds of great resources. Here now is another great resource for you if you're a worker, eCase. We are showing you right now the registration page for eCase. eCase is this tool that allows you, the worker, to see your claim folder. You can see all the documents in your claim folder just as we at the board do, or your attorney or the insurance company. You can see what everyone else sees. That's all you have to do is to register what's your name, what's your address, contact info. It's really this simple. And by the way, you'll notice at the bottom, we're asking you for a case number. If you have multiple cases, you register for each case individually. One day in the future, it's going to probably be different. But right now, you register individually for each case. You get your access like that, and you're all set. Recommend you do that. Let's talk now about the privacy provisions. Only certain parties, or people, we call them parties, may discuss claims with the, and there they are on the bulleted list. The injured worker and the worker's attorney, the employer, yes, the employer, the insurers and their attorneys, and then the healthcare providers. Everyone else who's not in that little universe of parties, these are the parties who are doing treatment, who got hurt, or who are paying and then representing legally. Those are the people who have the access. Everyone else, if the worker, repeat, if the worker wishes to share access, then the worker is going to fill out this form that's called a 110A form. Jen is showing this to you right now. This is called the 110A form because all of this is covered in the Workers' Comp Law section 110A. Very creative, wouldn't you say? So this form, the worker's name, designates the name of the person who the worker wants to share information with as able to hear details of the claim. That's all that is. So if you're a worker and you'd like your spouse or your child or a workers' advocacy group who's not your lawyer, but like the Workers' Rights Center of someplace New York, that happens. So you would fill in this form, you'd mail us the original, and then here are the details of your claim. Yes, Jen?
Which version do we mail?
The original 110A form.
Thank you, Joe.
You are welcome. That's a great question. You should have seen it. She actually raised her hand. Okay, so Jen, let's now start talking about the indemnity benefits. Okay. We're going to spend some time here. The first topic we shall cover here is right at the very beginning. The payer has the opportunity to accept or controvert the claim. Controvert is our way of saying dispute. So payer is saying, I don't think this is a valid workers' comp claim. Okay. So what do you do? Well, workers, we have some things we'd like you to know about. Number one, if the claim is formally disputed or controverted, the payers will be filing some documents. So if you have, well, technically, they're going to do it electronically, and the electronic action will create a document that you can read. That's to be very technical. But no benefits are going to be paid while the claim is controverted. Now, we do try to put the claims on what we call the expedited calendar, and we do try to wrap up the controversy in 90 days. But during this period, the payer is not going to be paying any benefits to the worker or to the treating providers. Now, the payer does have to cite one of a limited number of reasons. It's pretty defined. There are, I think, 16 or 18 reasons. I think it's 18 now. But a lot of them are pretty similar. They have to say, here's why. They can't just dispute just for the sake of. And what do you do if you're a worker and you're not getting benefits? Well, one thing you can do if you are not working because you're injured, you can file a short-term disability claim. Jen is showing us what the short-term disability claim looks like right now. DB 450 is what we call it. And while the disability claim is for injuries and illnesses that happen off the job that prevent you from working, if you're disabled due to what you think is employment and the claim is disputed, you may fill this in and you may get the 170 a week benefit, so you have something coming in. And then if your claim is established, don't worry about it. The two insurance companies, the comp insurer and the DB insurer, they'll trade money, they'll work it out. They're very good at this. If your claim's not established or disallowed, you probably would have qualified for the disability anyway. You got it. Okay, so just want you to know about that. That might help you in a period of financial need. Here now is an order that a judge might make known as CCP, carrier to continue payments. It means just what it sounds like. It means that the insurance carrier or the insurer should be making payments of this dollar amount. The judge will say how much. And the insurer has to continue making those payments until another judge or a board panel on an appeal says stop. So that's why it's CCP carrier to continue payments. If you're a worker and you get this order, that means you can count on getting those payments until someone else stops them. Let's talk now about a fundamental concept, the degree of disability. This is very important because it determines how much money you're going to get as an injured worker. Remember, if you're going to get indemnity payments, we need to know what you are earning, and then you're going to get 2/3 of that as a maximum up to a limit. But notice I said maximum. Okay, not everybody gets the maximum. Your degree of disability determines how much of the max you're going to get. So if you are totally disabled, look at the left side of that table. If you're totally disabled, that means you're 100% disabled and you shall get 100% of the maximum. The rest of those terms, marked, moderate, and mild, those are really old school terms terms that we used to use in the past to indicate the percentages that we're showing you. Marked is 75, moderate 50. So if you see a medical report that says you are moderately disabled, that means you're 50% disabled. That means you can get 50% of the benefits. Okay, that's how the percentages work. You're going to get that percentage of the benefit. And by the way, the doctors can rate you any percentage. You can get a 33% or a 40%. I saw both of those last week. They don't have to do it this way in quartiles, but they tend to do it in quartiles. They tend to go 25, 50, 75, 100. But now here, we're showing you the chart nice and clear. Total disability, you're going to get 100% of the benefit. That is what we call temporary total or permanent total. Okay, see, total keeps getting used. The other three are temp partial, permanent partial, because 75% disability will get you 3/4 of the benefit amount. And then 50 and a half, 25 and a quarter. And the last element on that table is important. The payment is capped or limited by the maximum benefit rate that was in effect on the date of your incident. So in our system, we do not have cost of living adjustments. Oh my gosh, Jen's coming up now. Okay, I'm turning it over to Jen for a poll.
All right, folks, let me take a moment and pull this poll up for you. So we are talking about Susan. Susan was 100% temporarily disabled and has been receiving $1,000 a week for the last 3 months. Susan's doctor recently said she is healed to the point where she is now only 50% disabled. Susan has never had a workers' compensation hearing. So, true or false? Because of her new disability percentage, Susan's benefits will now decrease to $500 a week. Go ahead and enter your answer, true or false. We'd like to see at least half of you participating.
Yeah, I think half is a pretty good threshold.
At least half.
At least, oh.
At least, folks. Okay, I'm seeing quite a number of truths and a couple of falses. We got a lot of no answers. Come on, guys.
Something about the way you read that, everybody just jumped right in. I think we've passed half.
Okay.
Can you?
I think so.
All right. Well, you know what? I always tell you the truth, my friends. I always do the question with you to see what exactly we're asking. True or false? Because of her, yeah, this is true. It is true that Susan's benefit will now decrease to $500 a week because she's never had a hearing. So that means there was never an occasion for a judge to lay down a CCP order. I know that we just taught you the CCP, carry continuum, so everyone's looking for a chance to put that in, but she hasn't had a hearing. So no, the payers may adjust her payment downward because she's recovered 50%. So she's only 50% disabled right now. And I would hope that at this point, you know, her employer might be thinking, do we have any alternative duty that we could, you know, offer Susan? Ken, I think I would like to just real quick go through some of the questions that just came in because
Sure.
they were absolutely just right on target. Okay, how far back does E-case go? It goes back to the beginning, okay? It goes back to the beginning of your claim. So still interested in E-case. If you're hearing me with an echo, Unless 50 people write in right now and say, I am too, then it's probably something on your end. You might have the audio open twice. That happens to all of us. Can the worker allow the provider to view the claim folder under 110A? You remember we just talked about e-case? If you want to give your provider the privilege to see your claim folder, you may. Or, well, what you would actually do is you would give us the ability to speak to your provider about your claim. You wouldn't give your provider e-case access, but we could speak to your provider about your claim probably anyway because they're treating you. But yes, if you want to do the form so that they can have access to everything in your folder, hearing about it from us, you may. That's your choice. Do you have to pay back disability benefits as a worker? Well, if your claim gets established, then you don't pay it back. The insurance company will pay it back, and your payments moving forward will be adjusted. That's what'll really happen. But if you're no, you don't have to pay it back because you were due those payments. Okay, Jen, let's move forward now. Thank you, everyone. We are going to now speak about the degree of disability, and I'm going to speak directly to our friends in the provider community. Hello. Thank you for joining us. A bunch of you did and do join us every time, and we love having you because you're treating injured workers, so thank you for that. And also, anything we could do to help you practice within the system, we're going to do it. So, here is an incredibly important thing that pertains to both providers and injured workers. Okay, there is this element of the comp system that says when a worker has a temporary disability, okay, this is limited to temporary disabilities. These workers who are receiving ongoing payments, that's the way we say lost wage payments, okay? Every 2 weeks, there's money moving to the worker for lost wages. That's called an ongoing payment. Those workers have to see their provider every 90 days at a minimum so that the provider can give a degree of disability. Remember when we started, we talked about how the degree of disability is a term in payment. Well, where's it coming from? The degree of disability is coming from your treating provider. So providers, you must do this. Now, workers' comp system, you're billing through your CMS 1500, you're using your electronic billing, you're billing electronically. Thank you very much. And they know what I'm talking about. And you're doing the CMS 1500, you need the report also. We are showing you on screen a template, and here it is. We've made it big for you. We need to go over this. Providers, you must file this. So the top of this form, all simple patient-centric, provider-centric info. Here's what we're talking about right now. You must answer these 3 questions or your patient's not getting paid. Number 1, is the patient working? All you have to do is indicate if the patient's working or not. Causal relationship. Okay. Is what you're treating the cause of disability, the reason why the person's not working? You're going to indicate that. And then finally, the temporary impairment percentage. That's another way of saying degree of disability. How disabled is the worker? You have to answer these questions, because if you don't answer these questions, especially the third one, we can't do the math that yields the benefits. Okay? So either use this template we gave you or put those 3 questions into your medical note templates. and just answer them in your templates. You can do that too. There's a major hospital in a major city in the downstate portion of this state. They just put the questions in their template like we asked them to. It makes things so much easier. So please do this. Now, new topic. Permanent partial disability. We've been speaking about a lot of temporary. The topic I just gave you was temp. There is a classification called permanent partial disability. And if a worker is classified PPD, permanently partially disabled, here's how it works. On the left, you see that LWEC? This is how the benefit is payable. We look at the LWEC. That's how we say it. We say LWEC. That stands for loss of wage earning capacity. It is a very complicated formula that fortunately all of our judges know how to do. The attorneys know how to do it as well. And the judge will decide the worker's loss of wage earning capacity, and that translates into a number of weeks of. So the most the worker can get when classified permanent partial is 525 weeks of benefits or 10 years. I did the math for you. It's 10 years. And then at the bottom, it's 225 weeks. That's 4 years. So workers who are permanently partially disabled get between 4 and 10 years of benefits. It's based on their LWEC. So if the worker is 96, has an LWEC of 96%, the worker gets 520 weeks of benefit, 525 weeks of benefits, and is going to get 96% of the maximum amount the worker qualifies for. So those percentages also mean what percentage of the maximum amount the worker is going to receive. Now, let's say we have a worker who's PPD, and unfortunately the worker's health deteriorates or decompensates, as the doctors say. That can and does happen. If that does happen, here's what the worker and the worker's attorneys definitely going to be involved in this, can do. They can show a change in condition. This is the change in the health condition of the worker. It's going to involve going to doctors, getting reports, getting the doctors to give opinions about how the work is today versus when the worker was classified 4 or 5 or 9 years ago. And you can bring it forward as the worker or the lawyer and ask for permanent total disability. That's lifetime payments of the maximum amount the worker qualifies for. You can also ask for total industrial disability. Total industrial disability is a very little used benefit, but it does pay the maximum amount of money for the worker's lifetime, and it has slightly different parameters or qualifications than permanent total does, as in you don't need to be 100% disabled to have total industrial disability. It uses other factors, vocational factors, facility with English language, age, I think, other things. So if you're a worker and you've gotten less healthy, consider permanent total or total industrial disability. Here are some quick best practices for those of us who are receiving indemnity. Number 1, I have no idea why you would not be on direct deposit if you're getting benefits, if you're getting payments. I can say that with a free and clear conscience. I have no idea why in the year 2025 you're not getting direct deposit if you can qualify for. If you qualify for a bank account, why don't you get one and get direct deposit, please? Second, if you're paid in cash, that's fine. Cash is still legal tender. Might not get a bunch of pennies anymore, but you could still get greenbacks. But here's what I recommend you do. Why don't you keep a record of what you got paid and who paid you and when and how much and what you did? Because then if you need a record, like, I don't know, you filed a comp claim maybe, and the board's saying, what did you get paid? Now you have a record. And then finally, this one about addresses is really important to people who work in cities, like, I don't know, New York City maybe? It's a heck of a town. But every place in New York City has an address. So if you're in, say, construction, and particularly if you're a day laborer and you go from job to job to job, and you got hurt at that job in Midtown, well, when you file a claim, it's not very helpful if you say you got hurt in Midtown. It's much more helpful if you say you got hurt at 77777 East 39th Street. Because now, if there's a dispute about who the insurance payer is, and there frequently is, we can pull the building permit. And then we know everything we need to know to quickly figure out who's the responsible payer instead of having to use. Thank you. All right, here's our biggest topic. We're going to spend the most time on labor market attachment. Here's what it is. It's the idea that workers who are temporarily disabled, temporary, this goes away when a worker is permanent partial or permanent total, unless it was raised when they were temp. But it's a temporary situation, and a worker is less than 100% disabled, so you're temp partial. Okay, if you're temp partial, the insurance payer can ask the judge to ask you, the worker, to demonstrate your labor market attachment. That means that you are part of the labor market, and colloquially it means, are you looking for work? So we are showing you right now this very large, very comprehensive website the board maintains that also contains everything I'm about to tell you. Okay, this is not Joe's opinion. Everything I'm telling you is on this website. So check it out. And what it means is the judge has said, all right, worker, you should look for employment within the scope of your restrictions. This is not actually stated like this in the law. It's coming out of what they call case law. It's the American Axle decision. That's the second bullet on the other screen. If you think you want to go read that decision, go on ahead. The insurance payer may raise this obligation at a hearing. So a judge has to ask you to do this. Now, what the worker is being asked to demonstrate is a timely, diligent, and persistent work search. Bullet number 4. Those are the 3 words, 1 adverb and 2 adjectives, that American Axle uses. So the appellate court came up with those. Now I mentioned that they're an adjective and an adjective and an adverb because we can't tell you the amount, the numerical amount of each. We can only tell you that the type of work search. We can't tell you how many applications or how frequently or when you have to do them. So we can tell you what type of search you can do. So now let's talk about that. Here are the things that the court said you might want to consider doing. you can use the New York State Department of Labor Reemployment Services. The good old department, known as our sister agency, may help people look for work, and you can take advantage of their services. You can go to their one-stop career centers, and you can use their computers and have them help you match to jobs and do seminars. You can also pursue full-time higher education. This is something we are, as an agency, we're very excited because Governor Hochul launched a free, free community college effort this summer. So if you're a New Yorker and you are between the ages of 25 and 55 and you don't have a college degree, you don't have an associate's, okay? You can pursue an associate degree in a high demand occupation. And the high demand occupations, there's loads of detail on them, but they're things like advanced manufacturing and healthcare. And Jen, it's like oh my gosh. So there they are, they're in the bullets there. So what you can do is you can go to college and you can use college to probably meet this labor market attachment. And Governor Hochul just announced this program where you can go for free if you meet the very simple criteria. So just want to call that out to everyone. Yes, this is for people who do not presently have an associate's degree. However, if you have 30 credits towards an associate's and you need another 30, if you meet the criteria, you can do this program. So some other ways that you can meet this labor market attachment is you can also use vocational rehabilitation. You can visit Access VR. We have voc rehab counselors here too at our agency, and talking to them doesn't, I don't think, meet the labor market attachment in and of itself, but you certainly should talk to them because they're very, very good at what they do. Now, once you've done these things, what do? Well, you're going to complete Form C-258. We're showing you the C-258 on screen. You can get it from our website. You might need more than one copy of it because you might have enough activities that you can fill 5 of them. Submit all 5. Repeat, submit all 5. It's okay to overwhelm the board with records of your job search. One thing you should do is include a resume. We love to see resumes. I'm not kidding. Now there is another route that you can pursue, and this is what they call the independent job search. So this is you applying for jobs. That'll get you there too. So I can't tell you how many to apply for. I can tell you, I don't know, if I was doing this, I would probably make looking for a job my full-time job. I think Jen might too. But what you do is you apply for your positions and then you fill in the form C-258.1, which is also on screen. And you see these bullets? This is just some common sense. You probably want to include the date that you applied and the name and the phone and the address of who you contacted and what was the position and what was the employer's response. And when you're doing it online as well, you want to include any sort of reference number. You can include a copy of the application. If you got email confirmation, and I bet you did, you might want to file that. Let's say you got an interview. You might want to indicate that. Let's say you got a job. Congratulations. So what you do is put as much info as you have on Form C-258.1 and file as many as it takes to record all of your searches. Jen, would you help us out again?
Yes, I will, Joe. So we've got another poll here for you. Give me a minute to just pull this up and open it up. So this is our friend Willie. Willie was 100% temporarily disabled per his treating physician. There's just been a hearing where an IME opined Willie is 50% temporarily disabled. A judge has just decided Willie shall receive benefits under a CCP at 75% disability rate. True or false? Can the payer now ask at the same hearing for Willie to demonstrate labor market attachment? True or false? Same as the last poll, we're looking for at least half of you to respond one way or the other.
So the key here, my friends, I'll give you a hint. It's a true or false. Can the payer ask for a work search at the very same hearing where the judge said you're 75% disabled, you're temp partial? Can this all happen at the very same hearing? Okay, look at them coming in.
I know.
All right, I was about to give you the answer, but people are just flooding them in. Okay, I'm going to give the answer.
Both closing people.
Oh, hey, if you were that one person, sorry. Yes, the judge can ask at the very same hearing for Willie to demonstrate labor market attachment. As a matter of fact, it's pretty predictable. What typically happens in the system is as soon as the worker goes from temp total to temp partial, the payer makes the calculation or the decision, am I going to ask? They don't always ask, but they can and they frequently do. All right, what's our next topic? Medical care. All right, we're going back to medical care, medical opinions. This is a pretty important one. So everyone, please. We have these medical treatment guidelines. We have 16 of them. They are part of Onboard. That's a computer program. And these medical treatment guidelines contain situations where a provider has to ask for prior authorization for treatment. Now, they happen in these situations. Number one, let's say it's a medication that has a non-formulary usage. We have a formulary for the meds, and maybe the provider wants to prescribe it for a non-formulary usage, they need a prior authorization. The second, a treatment that is not a medication that varies from the guidelines. So the guidelines say in this diagnosis, do this and this. Well, doctor wants to do that. Okay, doctor's going to have to ask for a variance. That's called a variance when you vary from the guidelines. And then finally, if there's treatment or testing that costs more than 1,000 American dollars, going to have to ask for a prior authorization or a PAR. I would like to now show you that process. Here's what the formulary looks like, by the way. So here's a quick peek. And now we're going to do the prior authorization process, or PAR, P-A-R. Here's how it works. It has 3 levels. What a great table. Level 1. The PAR request comes in, and for level 1, an adjuster or almost certainly a nurse at the payer is going to review it. And that almost certainly nurse is going to say approved, go get your treatment, or denied. If the level 1 says denied, the request is now automatically, no one needs to do anything, automatically escalated to a physician at the payer. And so that physician very possibly might approve. Different opinion with much more training and so forth. So if approved, go get your treatment. If not approved, if denied, the treating provider, not the worker, not the attorney, the treating provider now has to decide within 10 days, am I going to escalate this request and have the medical director's office at the board review it? That's the kind of thing a treating provider might do if the provider believes everything was stated, it's all crystal clear, we're just having a difference of opinion here. I'm confident in my opinion, so I'm going to ask the medical director's office for theirs. But on the other hand, let's say after 2 denials, the treating provider looks at it and says, they're asking me for this piece of information and I didn't provide it. So why don't I provide that piece of information and start again? That is perfectly acceptable, happens every day. So you're the treating provider, you can do that. Okay, so that's your level 1, 2, and 3 on this topic. Now we'd like to show you the review process for prescriptions. Because the prescription process is just a teeny bit different. It still starts at level 1, still probably a nurse is looking at it, but now if the nurse denies it, the prescriber has the choice to make here. The prescriber can decide to escalate it to level 2, which means I have to take an action if they think that they did everything as well as they could. So if you want to go to level 2 on a prescription, you have to take an action. You have to click some buttons to escalate it to the doctor. And then again, once the doctor reviews, if you want to escalate it to the medical director's office, you have to take the actions again. Okay, so the difference here is there's no automatic escalation with prescriptions. Independent medical exams. Oh boy, different topic. Very important. It's in with the medical because it is a medical opinion, but it's not care because there is no patient relationship, no patient-doctor relationship, between the IME and the injured worker. So that means anything you say, workers, can and will be reported. And also, not everything you say is accurately reported. And I'm only saying that because I have seen far too many instances of inaccurate reporting, I'm sorry to say. So, workers, what do? Well, you're going to probably have to go to the exam. You might not want to, but you probably have to go. You can bring a witness. Don't anyone tell you no. You can. You can record the IME as well, video and audio. You know that cell phone you never put down? You can record it right on that, or your witness can record it on the cell phone the witness never puts down. Don't let anyone tell you no. And you don't have to give prior notice. You can just do it. Why would you ever do this? Well, there's going to be a report, as we were just saying. And the report will have the findings of the examiner. And what you're going to do is you're going to read that report, and your lawyer will read it too. And then if there's anything in that report that's coming from your exam that you don't remember happening, well, you could go to the videotape. And if it's not on the videotape, you show it to your lawyer because they know more about this than a layperson does. And if the lawyer says, yeah, I don't know where this finding is coming from, it's not on the tape, well, you can then make a complaint to the, what's the name of Who gets that? The Advocate for Injured Workers? Oh, that's me. Okay, so you complain to my office. I will see it. I will read it. And I will almost certainly pass it on to the IME committee. Because we do have a health provider committee who does review these things, as well as other health provider issues. And this agency licenses the companies who do the IMEs. And we have, on occasion, not renewed a license or removed a license. So we're going to check it out, and the videotape helps. Also, you may claim travel reimbursement to and from the IME, good old Form C-257. And sometimes workers are asked to travel these enormous distances, especially upstate. So it could be a lot of money. So you can request travel reimbursement. Here now, some best practices for the payers, because we know there are payers on here, and welcome. We are very happy to have you here. Love talking to payers because then we could just make sure we're all on the same page. Like, for example, with 21A claims. Payers, when you have a 21A claim, check this announcement out. That allows payers to make temporary payments for up to a year without admitting liability. However, payers, here's the other side of that, and you must do this. When the claim is 21A, your payments must be consistent with the medical reports of the treating provider. Repeat, if the treating provider says 100% disabled, you have to pay 100% of the benefit. You also have to find out the wages. It's incumbent upon you. You can't just pay $325 a week. I'm sorry. You have to conform to the treating provider's opinion. You have to find out the true wages so you could pay the right amount. And then finally, what we're highlighting here, you may not, repeat, may not reduce the benefits based on an IME. So if you have a treating that says 100% disabled, an IME who says 0%, you have to pay 100%. You can't change the benefit based on an IME while it's in 21A. If it's not in 21A, different rules apply. But while it's 21A, this is what you have to do. Also, this next one is a big one. And I'm sorry if I sound like I'm lecturing, but number one, I do see 21A claims done incorrectly every single day. But now this one, let's look at this one. Jen, would you please open up that announcement? Okay, we showed you an announcement that was made 2 years ago. Here's an announcement that was made in July of this year. The board has 1 million, these are real numbers now, 1 million C 8.1Bs and 8.4s filed every year. Now, of those million, 400,000 of them have invalid reasons. Yes, 40% of them contain invalid reasons. So what we're doing here is we're showing you this bulleted list in the center of your screen. Those are 7 bulleted items. Would you please take a look at this later on? This is from January of this year. It's an announcement. You can find it on the site. And please take a look at these reasons that you should not be using on those dispute forms. I'm only going to mention the first one because it is by far the easiest one to comply with. Let's say the provider bills more than the fee schedule amount pays. Let's say you pay the fee schedule amount. You're done. You're done. You do not need to file a document saying, well, the provider billed more than the fee schedule. It's okay. And when I say it's okay, there's no action that's needed. you paid the right amount, go on to the next claim. Okay? So please take a look at this list and don't send those dispute forms in with those reasons anymore. I'm saving you all kinds of time and money, and you're saving the system all this time and money, because once we get those, we still need to do something with them. We don't just discard them or ignore them. We still do something with them. We're those kind of people. All right, next. Another thing that no one needs to do anything special with, a deposition fee. Let's say there's a deposition. The law clearly states money the provider should be getting paid. So payers, once the depo's filed, the law says you need to pay it within 10 days. Just pay it in 10 days. Do not, repeat, do not wait for a judge to say to pay what the law already says you have to pay in 10 days. Because if it comes in front of a judge, the judge might start thinking about penalties now, because the law clearly does say pay it in 10 days. Now, Jen, do you think you could pull the URL?
I can. Before I do that, there's someone in the chat who is, looking for oh, that's what you were asking for. I'm sorry. I don't know that I can do it while this is up without interrupting it. But if someone wants to drop their email in the chat, I can email it to you after this is over.
Okay. We do have these publications called efficiency enhancements. So we're going to ask you to maybe, that's what it looks like. So maybe go to the website and go to the bottom where we have the band of, clickable items, and click on the announcements page or click on efficiency enhancements. Okay. That'll get you there. Okay, let's go through the rest of these. That was us just, we got a question in the chat and someone wants to see these. So that's where you can find it. Also, if there's a hearing and the judge says we need a summary of payments, would you kindly submit that before the next hearing so that it's viewable and usable at the next hearing? And that goes for any item to anyone that the judge asks to please file. So just remember, if you're asked to file something before the next hearing, what the judge is really saying is file it in such a way so that we can actually see it at the next hearing. Also, payers, if you have a medical only claim, a med only we call them, and if becomes lost time, it's going to get indexed. So just be aware, if it's med only, it's not being indexed. If it becomes lost time, it will be indexed, and you will have certain clocks that start running, and you will have to decide on liability and other things. So that's just a little reminder to, keep everything moving for you. All right, Jen, let's see what's next. Oh, we're almost done. Appeals and settlements. Okay, people, appeals. Why don't we review the appeal process? Because I'll bet a lot of us don't know this. Here it is. Any judge's decision can be appealed. It has to be appealed within 30 days of filing, though. If you're a worker, you do get a little bit of slack on that 30 days because you're a worker, you're not a pro. But if you're a system pro, you don't get slack. You have to file it in 30 days. So it's going to go to a panel of 3 board members. There are 13 people who have been confirmed by the New York State Senate to sit on the Workers' Compensation Board. Okay, it's the name of our agency, but it's also the name of these 13 people. 3 of them are going to decide your appeal. Now, the payer does not have to pay benefits while something is under appeal. However, if the appeal finds that benefits are payable, they have to be released, and except for one instance in the last 5 years, they always are. There was one payer who just didn't get it. It was a payer who doesn't usually participate in our system. But yeah, so you're a worker, you're going to get your benefits now. But either party can appeal again. So now they get to make a choice. Who do they want to appeal to? They can appeal directly to the appellate court, but people don't usually do that because it costs money to go to the appellate court. Not a lot, in my judgment, or I think it's several $100 it might cost. But most people decide to go the free route, which is appealing to the full board, all 13. Now, remember they had that decision by 3 members? So the 0 or 2-1. If it's 2-1, that is a split decision. It's going to go to the full board. Okay, that is something that is going to happen. The full board will get it if it's a 2-1 vote. But if it's a 3-0 vote, one of the parties has to apply for full board review, and then the board at its discretion will take it or not. So if they do take it, then they will make a decision, and then from there, one of the parties can go to the appellate division if they wish. Technically, it's the New York State Supreme Court Appellate Division, 3rd Department. Then they'll make a decision, and you can even go on from there if you really want to. I don't know the last claim that went to the United States Supreme Court. It might have been the first one. But it is true, the first comp claim in the new accepted comp system did go to the Supreme Court. Okay, so that's how that goes. Now, let's talk about our last major topic. What's a settlement? A settlement is a term I hear workers using more and more frequently, and they're using it incorrectly. There's only one thing that is a settlement in this system, and that is a Section 32 waiver agreement. This is the website where we explain the Section 32 waiver agreement. It is it's an agreement between the worker and the payer to close the medical or close the indemnity or close them both permanently in exchange for payment today. And that's what makes it a settlement, because we agreed this is what we're doing and we're done. This is a big deal. This is permanent. Now, you can see right there on screen, see that settling your claim? Right, yeah, that link. That's a video. We made a video that you can watch, workers. It's 6 minutes. You're not investing your whole life on this. And it explains to you what a Section 32 settlement is, how the whole thing works, and you have to watch this video, by the way, if you're going to engage in a Section 32 waiver agreement. This is forever. So we like to make sure you understand exactly what you're getting into. We here at the board, we only review it, and then we either prove it or we reject it if it's unsound, legally unsound, like you did it wrong, legally unsound, or if it's unconscionable. But otherwise, it's probably going to get approved. And we do not negotiate it at all. We're not involved in negotiations at all. So this is between the worker and the payer. There you go. There's some more detail for you. It's entirely optional. We cannot compel the payer to sign it. We can't compel the worker to sign it. It's optional. Put it for you as an option in your workers' comp experience. Here are a couple resources, then we'll do your questions. Let's say you're a worker. Let's say you want an attorney. We can't give you a name, but we can give you these avenues to find a worker. If you go to the State Bar Association, they will send you some names of people who handle comp. If you go to the New York State Injured Workers Bar Association, this is the group of attorneys who tend to represent injured workers. They will give you some names. If you want to use a licensed representative, these are the people who took an exam that we gave that was extremely rigorous. I've seen it, it's extremely rigorous. And they passed it. So they are not attorneys, but they are permitted by license to represent injured workers. Well, if you want to check them out, you come to our website and you search for them and you can see the list. And then you can choose who you want to contact. Finally, let's say you have a medical only claim. So there's no money moving. The attorneys are not getting any payments. You're not getting any payments, but you need an attorney to help you get care. Well, you can go to the State Bar Association, nysba.org, and you select workers' comp, and they will send you of attorneys who have agreed to represent workers pro bono or for free. We have an injured workers toolkit on our website. This is a collection of all the many resources we have that workers can use. It's quite comprehensive. Those are all links there in black that Jen's going over, and they're all on this page. And we have so much helpful educational material here for workers. You have links to documents. Look at that. You want to find a lawyer? There's a bunch of links. Can't believe it. So there's the timeline. So take a look at this too if you're an injured worker. Would you like to follow the board and get our announcements and so forth? Here are our social media platforms. We recommend you take a look at these, sign up. Would you like to contact my office? Here's our contact info. Phone, email, send us an email. If you contact us, would you please have your board case number with you? If you write to us, please include it. Okay? And please, just give us a little context for your question, and we will respond to you maybe extremely quickly, maybe in 5 minutes. That happens. Okay, so it's question time now. So I'm going to turn it back over to Jen as I take a breath.
Okay, thank you, Joe. Thank you, everyone, for joining us. Give us just a moment or two here to kind of go through. We have many questions. We know that Joe already started answering a few a little earlier in the presentation. So just give us a moment to take a look at what else has come in. We'll be right back with you. All right, thank you for your patience. We're going to get started here. Our first question, when on a CCP, is it required at any point in time for an injured worker to be treated at an in-person exam versus a telemed visit to maintain a sufficient level of documented disability, or does it not matter whether the physician physically sees the injured worker when documenting a degree of disability?
We did the treatment options during the pandemic to include telemedicine. So that's the basis here. I do believe that there are criteria about how frequently a worker needs to have a physical exam in person and when the worker can have a telemed exam. I will confess, I cannot tell you the ratio. I can't tell you off the top of my head, and this is all off the top of my head, my friends. I can't tell you off the top of my head how frequently you do have to come in person versus telemed. I know that we have an announcement out there, so it's definitely on our website. So I'm sorry that I'm going to ask you to maybe search for that one yourself. But there is some formula or schedule or ratio.
Thank you, Joe. Our next question, what if they go back for medical services after PPD? Who is billed, workers' comp or private insurance?
This is an excellent question because it gets to the idea of lifetime medical. You're billing the comp insurer for comp care. The fact that someone is PPD is irrelevant to medical care. Yes, I said that. The fact that someone's PPD doesn't in and of itself mean a person does not need medical care any longer. That's why it's a lifetime benefit. So no, if it's comp care, you bill the comp insurer. Thanks, everyone.
Okay, I'm going to take this question regarding the first poll that we did, whether or not the answer to that was true. So as a reminder, this was our friend Susan. She was 100% temporarily disabled and had been receiving $1,000 a week for the last 3 months. Her doctor recently said she is healed to the point where she is now only 50% disabled. Susan has never had a workers' compensation hearing, true or false. Because of her new disability percentage, Susan's benefits will now decrease to $500 a week. That was true. Correct me if I'm wrong, Joe.
You're right.
Okay, so that was true.
Yeah, the key there was that it can come up and the payment is matching what the doctor said, and so unless there's a CCP and there wasn't, because she never had a hearing, then yeah, it can change. If someone does not understand labor market attachment, you're not the only person. It is a rather complex thing. So if you have a specific question related to labor market attachment, then I would be happy to answer. I don't want you to go away not knowing something. So if you have a question, give me something to work with.
The person requesting the URL regarding the C 8.1 invalid filings, if you could go ahead and drop your email in the chat, I will email it to you as soon as this webinar is done. If not, I'm pretty sure I might have it when you registered. We have a list of attendee emails, so no worries there.
If someone wants to go back to the settlement slide, why don't we just show the settlement slide? Okay, we're going to move back to the settlement slide for someone's knowledge. We love knowledge. All right, those are the questions we have. If you have another question, feel free to type it in. Please say, okay. Okay, someone submitted an application for board review on May 5. Yes, that could be true, that it hasn't been done yet. Yeah. May 5, that is 6, 7 months ago. Yes, it does take some months to do appeals. I'm sorry, but that's just the way it is. So if you wish to contact my office and give us some details, let us take a look at it. Okay, so to the person who filed for the appeal, send some details over to my office and let us take a look at it for you. Is there anyone else who has a question that maybe we missed? Well, we'd like to say happy holidays to everyone because someone's wishing us happy holidays and we wish it right back. To the person with the case number, no. Please write to my office with an email with your question and your case number. Here's the address. Give us something that we can, review and so forth, okay? Because like I could take your case number, I can look you up and then, who am I responding to? Happy holiday. Oh, you're welcome. You're welcome. We do want to help you, so please help us help you. Okay, do we have any more questions? Getting a lot of happy holidays. Jen, we're getting a lot of happy holidays. I know it's just okay. To the person who just wrote in about the daughter, okay, if this is a comp thing, write to us, please. Let us help you. So just take down that address, advinjwkr@wcb.ny.gov. Just write to us and let us help. Other than that, I think I'm gonna say happy holidays to everyone and talk to you next year.
Okay, thank you, Joe, and thank you to everyone for joining us today. Just a reminder, you can also sign up to receive workers' comp news, including information on future webinars, straight to your inbox. To sign up, visit the Workers' Compensation Board website, scroll down to the bottom of the homepage, and select Get WCB Notifications. We also distribute information channels, so please be sure to follow the board on Facebook, X, Instagram, and YouTube. We thank you all for joining us and enjoy the rest of your afternoon, and happy holidays to all of you.